Please be seated. In order not to unduly complicate this, I'll run over it one more time. What we'll do in these two cases is instead of 15 minutes aside, what we'll do is say there'll be 20 minutes aside. However, the appellants can take that 20 minutes and you can divide it up between you however you want to present both of your arguments, because you do have overlapping arguments. Constitutional arguments is just about identical in both briefs. So if you can decide that between you how you want to handle that, and then the state will have 20 minutes in its response, and then whatever time you reserve for rebuttal you'll have. So we'll hear the cases of Harris versus State and Morton versus State.
May it please the Court, Beverly Pohl of Broad and Cassell representing Jason Harris. One thing separates the felony offense of hazing from the misdemeanor offense, and that is the statutory term serious bodily injury. That term is not defined in the statute, and that is the crux of the big problem that permeated both the first trial in this case and the second trial. In fact, we come here from the context of the first jury being unable to reach a unanimous verdict because they couldn't decide what to do with the term serious bodily injury. So,
what's confusing about the term serious bodily injury?
Well, serious is a term of degree. I think that's the most confusing part.
Sure, but we deal with terms of degree every day.
But most often they're defined, especially something like serious bodily injury. Every time it appears in the Florida statutes, and it appears over and over and over again, the legislature has found it appropriate to define that term. Interestingly, each statute does not have the identical definition. And the state has pointed us to a decision from another jurisdiction, a federal decision, which has now a federal statute, which has even yet a different definition. And I think the most telling thing that proves our case that not everyone knows what serious bodily injury means is the fact that the trial judge in the first trial gave a completely different instruction.
Counsel, is it your position that the average person on the street in Florida knows what great bodily harm means but does not know what serious bodily injury means?
No, I think the term great bodily harm can be equally ambiguous depending on the factual context in which it arises.
What do you say about the states pointing out in their brief that we've had this ag battery on the books for decades and there doesn't even seem to be a constitutional challenge to great bodily harm?
There never has been a direct constitutional challenge to the term great bodily harm. So I don't think the fact that no one's ever squarely made that challenge means that it might not succeed.
Wouldn't you think there are more people prosecuted in this state for ag battery than for felony hazing?
Well, yes, because this is the first prosecution under the felony hazing statute. But it's very important to note that there's a long body of law in which, in certain circumstances, when it's been requested, there is a judicially approved jury instruction defining great bodily harm. And why didn't the trial judge give that? If this was essentially an offense that's indistinguishable from that one, which is what the state argues, the court ought to have given the indistinguishable instruction.
If the trial court had given a jury instruction that sort of paralleled criminal 8.4, which is your aggravated battery instruction, and simply said, ladies and gentlemen, one of the elements is caused great bodily harm, or in your case, serious bodily injury, and then said nothing more, would there be a problem here?
There would. Well, first of all, this ambiguity in the statute was challenged from the beginning in this case because the factual context in which it arises is not one in which everyone can universally agree constituted serious bodily injury. That was a central disputed fact in this case. And I do concede that there are certain injuries that probably everyone would agree constitute serious bodily injury. We wouldn't be here today.
So your constitutional challenge, then, I take it, is an as-applied rather than a facial challenge.
I think it's necessarily an as-applied challenge based upon the case law that says in order to succeed on a facial challenge, the statute has to be
Vague in all of its
that's right.
applications. And certainly if somebody kills somebody, that would qualify, everyone would agree that was serious bodily harm.
That's right.
Or
But
serious
so
bodily
looking at the
injury.
facts of this case, the question is it vague in this application? The best evidence of that is the fact that the trial judge did not define the term the same way in trial number 1 as opposed to trial number 2. That shows the learned trial judge who worked very, very hard couldn't do it the same way twice. And what did she do wrong the second time? 2 major mistakes. The first was that
Let's try to focus on the constitutionality. I understand there's some overflow on this, but I'd like to view these as discrete issues. I sort of think they are. And I just pulled out the murder statute, 78204. All criminal lawyers are very familiar with that. It uses this phrase, premeditated design. It's not defined in the Florida statutes, and it never has been. What does that mean?
Well, the fact that a statute does not define every term in the statute does not per se render the statute unconstitutional. But when a term is sufficiently ambiguous that this kind of discussion is being had, a court is supposed to look in one of a few places. One would be to analogous statutes, related statutes, to see if there's a definition there. And one would be to case law, determining what that phrase may mean in the context of case law.
Let me ask you this, then. Despite having argued otherwise in your brief, and I don't want you, Mr. Ufferman can make his own argument because he's also argued otherwise, but will you concede that permanent injury is not an element of this serious bodily injury?
It's an alternative. Quite honestly, under the definition of serious bodily injury in the DUI statute, which is the one that was advocated by the defense below, that is one of 3 alternatives. The first is that the injury puts the person at a substantial risk of death. The second alternative is permanency, and the third alternative is the loss of the function of a bodily part. So yes.
You're talking about 316-193?
Yes, 1933. Those are 3 alternatives.
Of course, 1933 is a legal threshold over which a law enforcement officer must go before he or she can take blood alcohol, and then it's incorporated into the substantive crime of DUI, serious bodily injury.
That definition reappears over several statutes, though, as the definition of what is...
Would you agree, though, that more specificity should be required where the statute contemplates invasion of a generally considered private matter, such as drawing blood from a motorist?
No, I would not concede that. It's the same term. If the legislature thinks that it doesn't mean the same thing in this statute than it means in some other statutes, then I think that highlights the need for a definition.
Ms. Paul, what is a permanent injury?
Well, I suppose a permanent injury is one that never goes away.
You know we've been litigating over what a permanent injury is for at least 20 years on the civil side, because you can't get pain and suffering damages anymore unless you have, among other things, a permanent injury. It strikes me that's a more complicated term than serious bodily injury.
Well, all I can say is nothing was provided. The jury was provided with absolutely nothing.
What if the judge had just said, the term serious bodily injury defines itself and is understood by its everyday common usage, period?
I don't think that's adequate. Because
why not?
Because serious doesn't mean the same thing to everybody. And if a jury is going to
Dog doesn't mean the same thing to everybody. You know, words, as Justice Holmes said many years ago, words, by their very nature, are not precise means of conveying ideas.
That's true. But I think in the criminal context, before somebody gets convicted of a felony, the law is that if there's any doubt, it ought to be construed in favor of the defendant.
Well, Judge Kahn has given you numerous examples in the criminal area where terms are at least as uncommon to the average Jane or Joe on the street as serious bodily injury, and none of them are defined.
And I gave an example in the reply brief that I think is apt, and that is if a fashion model got a small cut on her face, that may be serious bodily injury. If a hockey player got the same injury, not serious.
Wait a minute. Is this an objective standard or a subjective standard? If it's an objective standard, then it's got to be applied across the board the same way.
We're looking for some objectivity here, yes. It cannot be purely
So it doesn't
subjective.
matter whether it's a fashion model or a hockey player.
the point is that the jurors may view it completely differently. And the judge had said from the outset in this case, hazing may not mean the same thing to people in their common understanding than it means in the criminal law. I'm afraid I'm running out of time. I'm going to have to defer the very important argument on the instruction that the judge actually gave and why that instruction requires a new trial. And I'll reserve a couple minutes for rebuttal.
Counsel, I want to ask you one other question. I need in the matter of Mr. Harris. I have a bit of a concern on the question of whether or not there is a challenge to the jury instruction that was given in terms of the issues that are phrased for review on appeal. The constitutionality of the statute is clearly raised. Then there's a sufficiency of evidence as principle, sufficiency of evidence to prove serious injury. And then the contempt matter.
No, it's contained in the
challenge
brief.
the instruction per se, that is, as a discrete issue.
The discussion of the flaws with the instruction is contained in point number 1. If you look at the relief requested in point 1 and in the conclusion, it is there.
In the context of the constitutional challenge to the statute.
In the context of the flaws with the statute,
You don't really
that's right.
challenge the jury instruction until your reply brief, do you?
No, that's not correct. That's not correct. I attached the colloquy from the charge conference to the reply, but the initial brief certainly challenges the instruction and has a lengthy discussion of the problem with the trial judge omitting the word moderate from the instruction. So it is fully preserved and raised in this court.
All right, we'll take a look at it.
May it please the Court, Michael Lefferman, and I represent the other appellant, Michael Morton. I'd like to focus my time on the removal of the word moderate from the jury instruction given during the second trial. And if I can briefly summarize, during the first trial, the judge told the jury that serious injury is distinguished from slight or moderate injury. The jury, during its deliberations, came back with a question and said, we can't distinguish, or how do we distinguish between moderate injury and serious injury? The judge didn't answer that question, said neither rely upon the definitions given to you. The jury came back hung, and a mistrial was ordered.
Mr. Lefferman, would you still be arguing the jury instruction was legally inadequate if she had included the additional words or moderate?
I think that's our strongest attack on the jury instruction is the removal of the word moderate.
You'd be arguing this point anyway, wouldn't
Well,
you?
no, I think alternatively, of course, the defense had always wanted an instruction consistent with the definition of serious bodily injury contained in the DUI statutes. The judge refused to do that at both trials. But then now, so the key here is the jury during the first trial couldn't decide whether this was moderate or serious. Now we get to the second trial. We get to the charge conference. The prosecutor says to the judge, Judge, I want you to remove moderate. I think that was the problem that the jury had the first time around. And the judge agrees. So the state's burden of proof at the second trial diminished greatly.
Wouldn't you be here arguing, assuming that she had used moderate as well as slight?
Yes.
Judge, the trial judge did not define what was either a slight or a moderate injury, and therefore she didn't properly instruct the jury.
I don't know how to raise that argument.
Because if serious is not a term that the average person knows without a definition, which is the argument we've just heard, why would slight and moderate not also be terms that are not within the cognizance of the average Jane or Joe on the street?
Because I'm not conceding the constitutional issue, but I certainly want to focus on the moderate jury instruction issue. And I would say this. The state has said in their answer brief that serious bodily injury cannot be distinguished from great bodily harm. Now, the case law does say that a judge has the discretion not to instruct at all. So you ask, would it have been okay for the judge to not define serious bodily injury, say it defines itself? I might still say that it should be consistent with the DUI where that has been defined by the legislature. But if the state's right and these terms are indistinguishable, then the case law would control. However, the case law also says if you give a definition, it must comport with case law and the definition provided by case law. In the Smith case from this court last November, this court said great bodily harm is distinguished from slight, trivial, minor, or moderate harm. So pursuant to law, serious injury, if serious
Well, you're not suggesting, we were saying in that case, you have to include all of that in a jury instruction or it's inadequate.
I would suggest that you can say nothing, but if you're going to give a jury instruction, it has to be a proper reflection of the law. It has to comport with cases.
You always get into trouble when you start trying to draft jury instructions based on language in court opinions.
Well, sure,
I can attest to that based on my 22 years on the civil jury instruction committee.
But in the Chesnoff case, the court approved giving this great bodily harm instruction to a jury. They said it's okay to say it distinguishes slight or moderate. What would not be okay is to say it's only serious is only distinguished from slight. Because again, look at
counsel, you're suggesting to us that we have to accept that serious bodily injury means great bodily harm. Why should it have to mean
Well,
that?
the state has suggested that. I honestly, I'm not sure I can see a difference
You don't know
either.
what it means. Because it's unconstitutionally vague.
Well, I certainly adhere to that argument. But again, I want to bring the court back to first trial. Jury couldn't decide whether this was moderate or serious. It's very likely that this injury was moderate. We know that at least one of those jurors from the first trial thought that this was moderate. They didn't come back with a guilty verdict. They asked, how do we...
they thought it was moderate because of what they thought moderate was.
That's right.
But why does it make it necessary to put that term into this instruction?
Because how much...
When this simply says, it gives you a floor and says, do not consider things that are just insignificant, that is slight, and then gives you other, the instruction was more than that one sentence. It said the word serious, I believe, didn't it say when used to define the degree of bodily injury means dangerous, grave, grievous, or great as distinguished from slight?
And that's a big, so it gives you the floor and it gives you the ceiling.
It gives you
doesn't
all
give you
of
the
those
middle ground.
serious terms.
But it takes out the middle ground. This is the key. It takes out the middle ground. In the Smith case...
Why is there a middle ground?
Because Smith said there was. Smith said, at least for great bodily harm, that...
Well, this is not great bodily harm. This is serious bodily
The state
injury.
said it is. The state has conceded that they're indistinguishable. And I submit that a person...
Well, we're not always bound by state concessions when we're reading the law.
No question, but I think that that's a logical approach to take. And therefore, but again, focus on what was the state's burden at the second trial. All they had to show was that the injury was more than slight. And they seized upon that in their closing argument. The prosecutor said to the jury, all we have to do is show that this injury was more than slight. This injury was more than slight. At the first trial, they had to show that the injury was more than moderate, and they couldn't do it. So the prosecutor says to the judge, we couldn't meet our burden the first time around.
Are you arguing, for instance, that Mr. Jones's testimony that if by the time of the trial he still needed to sit on a cushion would have on its own been enough to carry that burden of showing more than a slight injury?
I think that there's a good argument that this injury is somewhere between moderate and serious.
Well, if you take I'm trying to separate in my mind, quite frankly, counsel, your legal argument on jury instruction from the facts of this case. Because if you take the case in the light most favorable to the state, with all due respect, I think you could line up a bunch of people and they would say it's a serious injury.
But at least one of the jurors on the previous panel didn't agree with that.
If you take it in the light most favorable to the state, they may not have believed the doctor's testimony, the guy from Atlanta. They may not believe that. But what I'm saying is, this is going to another point, sufficiency of the evidence.
Sure.
But if you take everything that they said, including the fairly complex surgical thing with having to have general anesthesia and all that, if you take all of that, which is what we look at for a prima facie case, it seems to me like you got a hard time arguing it's not serious bodily injury.
Well, okay, for sufficiency purposes, I'm not going to quarrel with the court today. For the purposes of giving a proper definition, again, the court perhaps didn't have to give any definition, but you cannot give an incorrect definition. And so when you distinguish it from slight, you must also distinguish it from moderate, because again, what are you doing to the state's burden of proof?
Well, I'll tell you my problem with the jury instruction, whether it's reversible error or not remains to be seen, so the state can feel free to respond. Here she gives an instruction which we seem to all agree, if she had just given the first sentence, you might still be here, but it'd be a tough row for you. Defines itself and is understood by everyday common usage.
And the moment she went further and said...
Then she goes and gives us dual definitions, which includes the distinction that leaves out moderate, and then the last sentence, which you haven't talked about, quite frankly causes me some concern, is that it's solely a question of fact, which suggests to me that it'll never be reviewed by a court because only the jury can find it out. And There's no standards.
That's right.
I'm saying that for the state's benefit so they can refute that when they get up.
I'll reserve the rest of our time for rebuttal. Thank you.
We'll give you 5 minutes on rebuttal.
Thank you. I appreciate that, Your Honor.
May it please the Court, Michael Kennett for Appalachia, the State of Florida. Both appellants raised 4 issues in this direct appeal. Most of those issues overlap. Starting first with the constitutional challenge to Florida's felony hazing statute. Both appellants argue essentially that because the statute lacks an express definition of the term serious bodily injury, therefore this statute is unconstitutional as being void for vagueness. Both appellants concede that there is no constitutional conduct at issue here. There's no overbreadth challenge, and apparently both appellants concede that there is no facial challenge here. It is only an as-applied challenge. With that, both appellants have failed to show that a person of ordinary intelligence walking out on the street today, contemplating conduct, would not know that the behavior in this case is prescribed by law. It's important to focus on the facts of this case and the injuries sustained by the victim in this case. What we have here is what Dr. Fern described as degloving. This is not a simple hematoma where there's a surface impact on the skin and capillaries break, blood forms, and then the body reabsorbs that blood.
But what about the defense expert? He disagreed with all of that, didn't he?
That's true.
And if we're talking about a constitutional challenge, this argument you're about to make now may have a lot more resonance on the instruction issue. But if we're talking about a constitutional challenge, you have a doctor who was qualified as an expert at the trial who says this was not serious bodily injury as a matter of law.
Well, first I would posit that an expert, a witness, is not allowed or shouldn't be allowed to answer a question that goes to the ultimate issue.
Well, and it was phrased in such a way at the trial that he wasn't actually asked the ultimate question, but it came pretty close.
Yes, sir, it did. But I would point to a case that both appellants supplemented with, and that is a recent U.S. Supreme Court case, U.S. versus Williams, where the U.S. Supreme Court talked about the problem that you're posing here and said the problem that poses is addressed not by the doctrine of vagueness, but the requirement of proof beyond a reasonable doubt. Yes, there may be a battle of the experts, or there may be state witnesses and defense witnesses who disagree about the nature of the injuries. But that is ultimately a question of fact that is up to the jury to answer.
But no. You're missing my point here. You're standing here now making the argument that in order to win an as-applied challenge, you have to show that the average person on the street would not realize that the conduct in question was prohibited. And you said every person on the street would realize this conduct was prohibited. Well, you got a medical doctor who doesn't think this conduct fits within the statute.
Yes, there was a battle of the experts. But, again, the focus is on would a person of ordinary intelligence, well, that expert, that witness for the defense, didn't say that the appellants didn't commit the crime of felony hazing. He just gave a medical opinion.
He said he didn't think it constituted serious bodily injury, didn't he?
From a medical perspective, sir, not from a legal perspective.
Oh, they're different.
Well, again, because the expert would not be allowed to testify as the ultimate issue, that is reserved for the jury.
If the average person on the street understands this term one way and a medical doctor understands this another way, then doesn't that support the argument that there needs to be some definition in the statute?
No, sir. That's why we have jury instructions.
Oh, okay.
Well, again, that doctor is not allowed to give his opinion as to whether the appellants are guilty or not guilty. The jury, who's going to receive instructions on the law from the trial court, answers that ultimate question. But the focus on the constitutionality of the statute isn't on the instructions. It's before the conduct ever occurs. It's a notice requirement. It's also a requirement that the statute would not lend itself to arbitrary enforcement. There's nothing in the appellant's brief to indicate that in any way this hazing statute would lend itself to arbitrary enforcement. And they have failed to demonstrate that a person of ordinary intelligence would not be put on notice that the facts of this case, the serious bodily injury sustained by the victim, would lead to possible criminal prosecution. And it's important to look at the actual facts. This is not a simple bruise. This is a situation where you've got fat tissue and muscle tissue, and because of the repeated blows and the force of the blows, that tissue separated. And blood, which had been flowing from the muscle to the fat, now pooled. So much so that Dr. Fern had to drain over 300 cc's of fluid from the victim, and that was not enough. Also, that fat tissue no longer received blood and oxygen, and it became necrotic and died.
It seems to me what you're doing now is precisely what you just told me you can't do. You're relying on the state's experts' testimony. I mean, if we're going to look at the statute, we're going to look at the statute based on what the average person on the street would think. And apparently, there's considerable dispute about whether the average person on the street would think this conduct violated the statute.
But Dr. Fern is the one who actually treated the victim in this case. The defense expert, Dr. Lee, did not actually treat the victim. His testimony was not factual. The testimony of Dr. Fern was, in fact, factual. It was not just his opinion. It was facts. What did he observe? What did he do in order to treat the victim? He had to put the victim under general anesthesia to remove necrotic tissue, necrotic fat tissue, and necrotic skin. That is factual. Nothing from Dr. Lee was ever factual. So that's why I point to Dr. Fern's testimony as the facts of this case. Facts that Dr. Lee did not personally witness as a recipient witness in the case.
Would it be reasonable to suggest that maybe the expert doctor is not the average person on the street?
Certainly that would, and he is not the standard by which this court should judge the constitutionality of the statute. It is the ordinary person on the street contemplating conduct. Is that person on notice that conduct is not prescribed by law?
Counsel, you're here with sort of the monumental responsibility of representing not only the Attorney General, but the people of the state of Florida. In the brief, which I'm not sure you wrote the brief for the Attorney General.
I did not, sir.
But in that brief, and in these briefs, your colleague, Mr. David, suggests that, well, this, stripped away of all the fancy language, this is a garden variety aggravated battery case. And here's my question to you, and this is a policy question. If the state of Florida is going to put itself to the task of prosecuting these boutique types of crimes that come up in reaction to perhaps public outcry against particular instances, then why, when it's covered by another crime, quite honestly, and I think you know that as a lawyer, your co-counsel did, then quite honestly, why shouldn't the appellate court put you to the test and require you to, because in fact, you have to, your colleague, when I read his argument, I'm thinking he's almost arguing a greater included offense. He's arguing that ag battery has fewer elements than felony hazing. And I think there's some substance to that argument, that you all chose to prosecute under felony hazing. Why the state attorney did that, nobody knows. Who's involved in that decision, nobody knows. But my bottom line question is, why shouldn't we hold you to the burden of proving and trying this person exactly under this brand new statute that has no guiding case law under it?
First, I would say that upon review, the felony hazing statute is separate and distinct from ag battery, because in a felony hazing statute, there is no no defense of consent.
Correct.
Which you can consent to a battery. People play football, they play other sports, and they consent to body contact. By having a hazing statute, the legislature essentially removed the consent defense from this type of behavior. And we could argue why they did that, the policy concerns. Is it sort of an adhesive situation where...
I'm with you on that, and I think that's a really good response. I credit you for that. But I think that sort of may even support my point, which is that the legislature has, in essence, taken away a traditional defense to aggravated battery. Isn't that all the more reason we should really hold the state's feet to the fire before they convict someone of this particular new, brand new statutory offense that doesn't have any antecedent in the common law?
Certainly. Certainly, the court can scrutinize the state's decision to prosecute. That's fine.
No, I'm talking about the proof and the way the trial went. I'm not talking about the decision to prosecute. That's really not our field.
I'm sorry, I misunderstood your question, sir. Well, it is a new statute. But, again, looking at the facts of this case, it does appear to be a situation where consent could have been a defense to an aggravated battery charge. And for whatever reason, given the many tools he had, the prosecutor chose to charge under this statute. And going back, the appellant has failed to show how this statute is unconstitutional as being void for vague. We can disagree about whether it should have been charged as X or Y, but again, the bottom line is the appellants have failed to show that it's unconstitutional what's being voided.
Maybe I misunderstood Judge Kahn's question, but I think he was indicating he's more concerned about the way the case was tried, and including the jury instruction, when he's talking about why shouldn't we require the state to dot all its I's and cross all its T's if it wants to use this special statute.
Well, going to the jury instruction question, the trial court is not required to give an academically perfect definition or an academically perfect instruction. The trial court has broad discretionary powers to instruct. In this case, the trial court did not abuse that discretion. In the absence of an express definition in the statute, the trial court was free to look to other statutes, case law, and common ordinary usage.
And I don't think any of us disagree with that. The problem we all have, I think, is the fact that she instead of stopping at the end of the first sentence and saying this is a common everyday term that y'all ought to be familiar with, or instead of saying a serious bodily injury is different from a slight or a moderate bodily injury, she left out moderate. And you're right, you don't have to give a perfect instruction, but you have to not confuse the jury. Can't we agree on that much at least?
Yes, sir, we can, but there's nothing to show that the jury was confused. What the appellants essentially argue is that...
Well, there's some circumstances. I mean, I'm surprised you bring that up, because there is some circumstantial evidence that a jury was confused by an instruction that dealt with degrees of this offense in the previous trial.
Correct, but contrary to the...
I wouldn't want to get into that if I were you.
We don't know why the first trial ended in a mistrial. There are certain questions...
Wasn't there a specific question about the definition of serious injury?
Yes, sir, there was. That does not mean that that was the issue that hung the jury. We don't know that.
Absolutely, you're right.
And so it's just a presumption on everyone's part. But setting aside whether the instruction in the first trial is even relevant, it doesn't show that this statute is unconstitutional or that the judge abused her discretion. It just shows it's a new statute, and the Florida Supreme Court has yet to promulgate a standard jury instruction. In the absence of that, the trial court did its best to fashion...
But you do have at least two. I mean, I may have missed some, but you've got the ag battery instruction, and you've got 28.3, which the defense, I think, discussed at trial. The ag battery instruction doesn't give a definition of great bodily harm, and the 316.193 gives this definition, and I think it finds its way into the third sentence of the instruction that Judge Decker actually gave. So there are some definitions.
Yes, initially, the trial court just wanted to leave it at the first sentence, but it was upon prodding from the trial defense counsel that she added language. And some of the language she didn't want to use...
Well, she didn't. I mean, let's be fair. I don't think she added the language, actually, that defense counsel wanted, because didn't they always insist upon the distinction between slight, moderate, and whatever the third word is? With
the exception of the term moderate, and she also took out language talking about the risk of physical harm.
Didn't the assistant state attorney specifically argue in at least two places during that jury charge colloquy that moderate was not necessary?
And it wasn't, sir. And to demonstrate why, the jury was instructed that in order to find the appellants guilty, they had to conclude that the state showed with proof beyond a reasonable doubt that these injuries were serious. So if it wasn't serious with proof beyond a reasonable doubt, then everything else by default would have resulted in a not guilty verdict. So it doesn't matter how many adjectives we have in between serious on one end of the spectrum and slight on the other. It doesn't matter if the word moderate was there or not, because the state does not need to prove what the injuries were not. Nor does the appellant need to show that the injuries were only slight. The appellant seems to suggest that the jury was faced with one of two possibilities. Either the injury was slight, or if it wasn't slight, it must therefore by default be serious. But that is not the manner in which the jury was instructed. They were again told the state must show with proof beyond a reasonable doubt that the injuries must be grave, dangerous, grievous, or great. If it's anything else...
That would have been a very difficult instruction for them to overcome. But I still think you have to get back to the actual instruction that she gave, which, again, I would suggest mixes up at least, I've counted it a few times, at least 4 different concepts is what I see in it. Had she never gotten into the matter of degree and had overruled their objection there, I think they might very well be out of luck. But once she got into that matter of degree, how do you then say that she didn't have to at least follow the correct law on that? And by the way, I agree with my colleagues that you get into trouble giving jury instructions out of case law. But she did.
Right. And she explained on the record why she did not use the term moderate. And one of the reasons why was because she looked up the definition of the term serious in several dictionaries, and she said on the record that those definitions did not include moderate. They had opposite ends of the spectrum, serious on one end and slight on the other. Again, there are a lot of
that doesn't seem to be what at least 6 District Court of Appeal decisions, including 2 out of this court, say. Now, they're on ag battery. The issue's a little bit different. It's sufficiency of the evidence. But where you can see there are a number of decisions that draw 3 degrees as opposed to 2.
Yes, but that's not a requirement. Again, the focus is on whether the injuries were dangerous, grave, grievous, or great. Because if they weren't, if the jury only thought that these injuries were moderate and that jury followed the instructions, they would have voted not guilty. Because moderate is not dangerous, grave, grievous, or great.
Except for, now we are getting into semantics, except for her use of the phrase as opposed to slight, which suggests, and you know, we wouldn't be practicing law if we knew anything about mathematics, but I do think that when you say as opposed to slight, one may argue that you're excluding slight but nothing else.
Well, how many degrees would the trial court need to have? 2?
The case law has 3. That's all I can say, and it may be counting the angels that dance on the head of a pin, but the case law has 3 degrees.
And perhaps 3 degrees would have been a perfect instruction. But the trial court was not required to give an academically perfect instruction. There is no requirement in the case law that it be perfect. And if the Florida Supreme Court issues a standard jury instruction, it may differ from the one given by the trial court in this case. That does not mean that this instruction is fatal. Moving on to the sufficiency of the evidence. The moving party, the appellant, must accept all the reasonable inferences that can be drawn from the state's evidence, focusing on the nature of the injury sustained by the victim, that degloving, the separation of the fat tissue and the muscle tissue, clearly showing all inferences in light most favorable to the state. Serious bodily injury was, there's enough evidence, there is substantial and competent evidence to sustain the conviction on that issue. Now, regarding causation or the principal theory of liability, there is testimony that Appellant Harris was called Daddy Swagger, that he told the pledges who were passing out from the pain to get back in line, that he actually poured water on them to revive them. Nothing that Appellant Harris did was Hippocratic. He was not rendering medical assistance to help them out. All he was doing was reviving them so they could have more pain inflicted upon them by members of the fraternity. Clearly, that is principal liability, looking at the facts in the light most favorable to the state. As far as causation goes, again, looking at the facts in the light most in the best light for the state, causation, there is substantial and competent evidence. For Appellant Morton, there could also be a principal theory of liability for him as well. He was Daddy Go Foreplay. There is testimony that he was the head daddy. He was in charge of this hazing ritual. So not only for Appellant Harris, but for Appellant Morton, there is principal liability, substantial and competent evidence to support the conviction. Now, moving on to the last issue, which is the sort of post-trial disqualification of the judge, neither appellant has shown that there was any hostility on the part of the trial court towards Appellant Harris's trial defense counsel, nor has either appellant shown that there was any effect that that purported hostility had on either appellant. And it's important to note that because Appellant Morton was not represented by the same counsel as Appellant Harris, who was the one who was held in a contempt of court, or was issued in order to show cause. So all we have is a blanket assertion by the appellants that somehow the trial court harbored an animosity and that somehow, without being defined or established by the appellants, that hostility prejudiced the appellants. There's no evidence to support that. It's important to note that the trial court took great pains not to issue the order to show cause or embarrass or admonish Harris's trial defense counsel, that she waited until after the jury had rendered its verdict. And that is one of the important considerations for those types of admonishments. Did it occur in the presence of the jury? In this case, it did not. So in conclusion, the state asks that the conviction and the sentence be affirmed in this case.
We'll give you 5 minutes. Y'all can divide that however you need to.
I just want to supplement by saying that the argument in Harris's initial brief pertaining to the faulty jury instruction and requesting a new trial on that basis, separate and apart from the constitutional issue, is contained in the initial brief, both at page 1819 at the conclusion of the summary and also at pages 33 to 35.
We do have, though, to take up Judge Barfield's theme somewhat, we do have a body of case law. I don't know that we've said it recently, but I know we said it in the 80s and 90s, specifically with regard to criminal cases, that a discrete point on appeal is required to make an argument that would alone support reversible error.
I think it is a outgrowth of the constitutional question, because that's the way it's presented in point 1. Either the statute's unconstitutional, or if it's not, then the instruction that was given requires a new trial. That's the way it's presented. If that's not in keeping with this Court's precedents, we apologize. There was a point made earlier.
It's more serious than that. If it doesn't satisfy this Court's precedent, then we can't consider it.
It's argued at length in the brief.
Under a different issue.
The specific relief is requested in the conclusion of the argument and in the conclusion of the brief. And, you know, it is what it is. I think it is solidly presented.
That sort of raises the question, and, you know, appellate courts do sometimes stand on procedure and precedent. It's not like, you know this as well as anybody, it's not like TV where you just come in and say whatever pops into your mind. Your reply brief actually includes the jury instruction in the statement of the issue. The initial brief does not. What should we glean from?
Well, we focused on that in the reply to the exclusion of everything else, but that doesn't mean it didn't occur in the initial brief. But we made a decision in the reply to focus on that one issue, and it doesn't mean it was raised for the first time. I don't think any fair reading of the initial brief in this case could support a conclusion that that jury instruction argument wasn't raised by Appellant Harris. There was a question raised or a comment made about we don't know why the first jury was hung, and I would refer the Court to the October 9th transcript in which the first jury asked a question saying, quote, how do we distinguish between serious and moderate injury? And only a few pages later, the jury came back with a note saying, we continue to be unable to arrive at a unanimous agreement on all of the elements. So I think that
the state's response to that, as you've already heard, is we understand what the factual scenario was, but we still don't know because we weren't in the jury room why they hung.
I think it's a logical conclusion that one would draw. They asked for an instruction on an element.
It's a possible inference.
It is. With regard to principal liability, although I didn't argue it previously, the state has brought it up, and I would just like to say that there is absolutely no evidence linking Jason Harris to anything that occurred on the Thursday and Friday night, nor
Well, but that's a question. You're talking about February 23rd, 24th?
Yes.
Isn't that a question of fact for the jury that really goes to causation, though?
No.
Because there's no doubt, I mean, and again, I'm going to propose to you, there is no doubt but that your client, in the light most favorable to the state, encouraged Mr. Jones to get back in the line. I've seen what it previously
I respectfully disagree, because even viewing the facts in the light most favorable to the state, there is literally no evidence from any witness linking Jason Harris to Marcus Jones. None. None even saying that Harris was there on Thursday and Friday, and the only witnesses who talked about the Sunday and Monday evenings, there's nothing linking Jason Harris to Marcus Jones.
So the evidence of Harris saying, get back on the line, be a man, tough it out, did not specifically relate.
That's
to
correct,
Jones.
Your Honor. That's correct. The
You've
state.
got about a minute left if your co-counsel wants any time for rebuttal.
Oh, okay. I don't want to deprive him of that.
May it please the Court, and I'll be very brief. I just want to quote from the prosecutor during closing argument. This is at page 1158. Serious is distinguished from slight. The injury sustained by Marcus Jones was by no means slight. The prosecutor seized on the opportunity at the second trial to tell this jury that moderate wasn't necessary. All they had to show is it was more than slight. And that's what he argued. That's exactly when earlier during the charge conference, the prosecutor said, I think that's what led to the confusion, or at least part of what led to the confusion last time, referring to the moderate definition being as part of the jury instruction. The state's burden was much lower at the second trial simply because the word moderate was removed, and I'd ask this court to reverse for a new trial where the judge could either give no instruction, or if the judge is going to instruct and include these degrees and distinguish from slight, consistent with case law, she must also distinguish moderate injury. Thank you.
Thank you very much. We'll hear